Good day, everyone, and welcome to the ISTAT Learning Lab. Today, we'll be discussing one of the more interesting and complex topics that I've seen in my near 40-year career in aviation. We'll be discussing the insurance issues arising out of the Russian-Ukrainian conflict. As you recall, at the start of the conflict, severe sanctions were imposed by Western countries, which required leasing companies and aircraft financiers to cease leasing and financing in the Russian Federation. This impacted over 400 aircraft, having a market value in excess of $10 billion. In response to this, the Russian Federation effectively prohibited return of these aircraft and facilitated re-registration of these aircraft on the Russian Aircraft Registry in violation of the Chicago Convention. With no practical ability to repossess the aircraft, the lessors of most of these aircraft turned to their insurers for recovery. Claims were denied and litigation has ensued. In this lab, we're going to take a deep dive into the arguments raised by the lessors and the defenses submitted by the insurers in respect of this litigation. I think it's fair to say that this litigation is being closely watched by many of us in the commercial aviation space, and the outcome could have significant ramifications for how we assess and protect against risk on a going forward basis. So we thought it'd be good to get an update as to where these cases currently stand and what arguments are being made on each side. There's Q&A buttons and chat buttons, and I'll be monitoring this during the course of the discussion, but we're fortunate to have Alison Weal here today to help us unpack all of this. Alison's a knowledge counsel at Watson, Farley, and Williams in their assets and structured finance group. She specializes in aviation and shipping finance and has over 20 years of experience in these sectors. I should also point out that Watson, Farley, and Williams acts on a good number of matters on behalf of the Aviation Working Group, so she may have a unique perspective on all of this. So with all of that, I'm going to hand it over to Alison for our presentation. Alison, good day.
Thanks very much, Dean, and thank you to ISTAT for giving me the opportunity to speak to you today. I'm just going to share my screen, so hopefully you can all now see that. And let's just check that we can move on. Yeah. Okay, well, thanks very much, Dean. You've given a good introduction as to why we're speaking about this. Over the past year, there have been lots of claims that have been brought in the courts by aircraft lessors against their own insurers as a result of the events arising from the Russian-Ukraine conflict. And as well as making claims against their own insurers, the lessors have also been making claims against the airline insurers. We're not going to focus on that for the purposes of this session, but it should be noted that there are ongoing litigation on that matter as well. So what we're going to look at for this session is the common themes that are raised in the litigation against the lessors' own insurers. And these are spanning multiple jurisdictions and numerous lessors as well. I would highlight that I am not intending to discuss the merits of the specific arguments that are being brought in the litigation and the positions that are being taken by the lessors. I'm not a litigator and I'm not a judge either. And I will instead be focusing on the arguments that are raised and the defences that are being levelled to those arguments by the insurers. So if you do have any questions, please bear that in mind, and please don't ask me any of my thoughts on the merits of these cases. So just as a bit of background, you may not know exactly what the lessor insurance policies consist of. Most leasing companies will maintain their own insurance policies, which will be in addition to those that are being maintained by the airlines in respect to the aircraft that they're leasing. The lessor's policies will generally cover two elements. There will be a contingent cover and possessed cover. Now, the contingent insurance cover provides insurance for where an airline has failed to adequately insure an aircraft, or where the airline's insurers don't pay out after a valid claim has been made on the insurers in certain circumstances. That's the contingent element of the policy. The possessed element, possessed coverage, gives cover where an aircraft is in the possession of the lessor or where it's in the process of being repossessed. We'll look at both of these elements in a lot more detail later on. But it's under these two elements of the policies where we have seen these claims that have been arising up to date. So just as a little background on the status of the litigation, we've seen litigation commenced in the UK courts, the Irish courts, and various US courts as well. The first was around June last year, and there's been a fairly steady trickle flowing through the courts during the rest of last year and the early part of this year. So where we are now is that in most cases, I think the defences have been filed by the insurers, and in many cases, we've also seen replies or responses to those defences having been filed by the claimants. The claims that have been filed are generally fairly brief and succinct in nature. They set out the claims and brief descriptions of the basis of the claims. And I think the idea is that the legal arguments, including relevant case law, will be developed further as the cases proceed. The defences that have been lodged by the insurers are slightly different depending upon the jurisdiction that we're looking at. In the UK and the Irish cases, they're fairly detailed and specific. They respond to each claim with admissions and denials, and they set out detailed rationale for the position. So, for example, it might say the defendants are not liable because there is no physical loss due to X, Y, or Z. In the US, the defences tend to be a little bit more general. They don't specifically respond to the points that are raised in the complaints, but they do say more generically something along the lines of the defendants will not be liable to the extent that the claims do not involve loss or damage to the aircraft. And then whether there is loss or damage to the aircraft will be expanded upon as the cases proceed. I think the other interesting thing to note is that when the first case was filed, the insurers were grouping together and filing their defences as a group. And then as more and more cases have been filed, the insurers tend to now be defending on an individual basis. I think the reason for this is essentially they're realising how many cases were being brought, and they want to make sure that they're providing consistent defences across all of the different cases, and that perhaps there may be some disagreement between insurers as to how to actually proceed with the defence. So you'll see as we run through the session that notwithstanding the fact that we're looking at different jurisdictions for these litigations, there are a number of recurring themes that are arising in these cases, albeit with their own jurisdictional spin on those points. And we'll look at those in a little bit more detail. But in terms of where the court, these cases are going to go to court, it's going to be an ongoing matter. The timing is not going to be anytime soon. We have a number of cases that have been brought in the UK court that sound as if they're going to be heard together in a 12-week court case scheduled for October 2024. And there's also a number of US cases that are being grouped together as well to be heard at the same time. In Ireland, recently it's been announced that I think they're looking to hear all the cases at the same time, and I think at the moment they're just working out whether there's actually going to be a venue big enough to be able to do that, because once you add in all the lessor parties, all the witnesses, etc., there's going to be a lot of people. As I said earlier on, there's also the cases that are being tried in respect of the airline insurers, and these are bringing up their own issues. For example, should they be heard in Russian courts or English courts, for example, depending upon where the reinsurers are based. So that's all underway. But as I said earlier on, we're not going to be looking at the airline cases in any detail in this session. So looking at the recurring legal themes that pop up, as mentioned, even though we're talking about various jurisdictions, we do see So we do see some themes cropping up time and time again, and we'll look at some of those in more detail now. However, again, I just want to reinforce the note in red here. The slides are setting out the common themes. Lessors are arguing things differently, and also we're not going to comment on whether they're the right arguments, whether the arguments have merit. I'm just going to give you the factual information that's cropping up time and time again. So this chart, I think, is a good chart to really show the amount of issues that are actually involved in these cases. And essentially, I think they can be split into factual, legal, and interpretation points. Originally, when I was preparing this chart, I had split those three types of issues up into three different colours. But actually, when then looking at it further, really, it was quite difficult to actually allocate each issue to a type of issue. So whether it's factual, legal, or interpretive. And actually, some of them involved a bit of a blend of more than one type of issue. So, for example, up at 12 o'clock on the chart there, you'll see a circle with physical loss. Originally, or initially, you'd think that that would be a factual matter. But then when considering whether there's been a physical loss, it leads into legal concepts such as whether there's been an irretrievable deprivation of the asset, or whether the concept of constructive total loss applies. And then if you look down at 6 o'clock on the chart, you'll see the phrase "in the course of repossession." That's become very much an interpretation issue because both the lessors and the insurers have entirely different views of what "in the course of repossession" means, which we'll see later on. So what comes out of this chart is that there really is a myriad of issues that are involved in this litigation. It's really very, very complex. So we'll now start having a look at some of those types of issues. And the next few slides are all set out in the same way with these charts here. I've put on one side of the chart lessor arguments and on one side insurer defences. Now, there's probably a little bit too much information on these charts, but it's all helpful stuff. So, please feel free to have a look at this in your own time. I would highlight that the next few slides, I am mainly going to be talking about this from the UK and or the Irish perspective rather than the US perspective. But in any case, all of this is going to be fairly broad brush. And as I've said, different lessors are running different arguments and maybe running those arguments slightly differently as well. But the first issue that we are looking at is what type of loss has actually been suffered. And so the main question that we need to consider for this is, what do we actually need to prove to show loss? And this will differ according to jurisdiction. So, for example, in England and Ireland, the lessors have been arguing that there's physical loss by way of an irretrievable deprivation. In the US, the phrase irretrievable deprivation doesn't come into play. And when looking at the type of loss suffered, it really is a mixture of factual, legal, and interpretation issues that arise for the question. So first of all, has there been a physical loss? Now, as I said earlier, this could be seen as a factual question, but it's actually going to lead to other elements. So, for example, is the test for a physical loss one of an irretrievable deprivation of possession of the aircraft, which is actually going to then amount to an actual total loss of the aircraft? So there hasn't been any physical damage destroying the aircraft, but the lessor's being deprived completely of the use of the aircraft. There's plenty of case law on the point, but even that raises a number of subpoints, such as, can deprivation of possession be irretrievable without a further lapse of time to wait and see if you get the asset back? Or has there even been a deprivation of possession? Could the aircraft still be returned? One of the arguments that the insurers are putting in their defence is that purportedly the lessees are willing to give the aircraft back and have stated that they're willing to give the aircraft back. They've just got to be able to do so. And so if the lessees are willing to return the aircraft, is there even a deprivation of possession? So all of these points are involving factual considerations in respect of the actions that have been taken by the Russian government and subsequent actions that the lessees have been taken. But also there's the legal considerations as regards what actually is an irretrievable deprivation. Now, some lessors don't necessarily think that irretrievable deprivation is the correct test, or if it is, but the court decides that it isn't, maybe the test is whether that there's been deprivation of physical possession where recovery of the asset is either uncertain and or unlikely within a reasonable period of time. Now, again, this is going to give interpretation issues. What is a reasonable period of time? Was recovery unlikely or indeed uncertain? And then lessors have further been arguing that potentially there's a constructive total loss, which is seen in the English and the Irish pleadings again. And a constructive total loss is where the estimated cost of repairs would exceed the insured value of the property. Now, the insurer's defence on this raises the concept that this is actually only a marine insurance law concept and doesn't apply to aviation at all. So again, there's going to be, I think, a lot of consideration by the courts as to whether some of these concepts even apply to an aviation scenario. Then you'll see from this chart as well, in the second row of the lessor argument section, that there's the argument being run that the aircraft was in the grip of a peril, which again is something that we're seeing in the English and the Irish pleadings. Now, there's again plenty of case law around this point. And what in the grip of the peril essentially means is where an actual total loss has only been established as occurring after the policy period has ended, but by reason of a peril whose effect commenced within the policy period. We're seeing from the insurer's defence that again, they're saying, well, this should only be a marine insurance law concept and not an aviation concept. And there's also going to be the factual question here as regards timing as to when the loss occurred, when the policy ended, etc. And this particular argument will link into a point that we'll be discussing later on regarding the cancellation notices that were served by war risks insurers. In respect of many of these arguments that the lessor has been raising, what we have been seeing coming from the insurers as a defence is the wait and see concept. So what the insurers are saying here is there wasn't any actual total loss, and all that was the case was that there's a wait and see scenario in play, and that we just have to sit back and wait and see what happens. But again, this has numerous points that are going to arise in arguments. So if once proved that there actually was eventually a loss after the wait and see period ended, would that loss relate back to the original events of the Russian government actions or the lessee's actions? Or does it relate to when the wait and see period ended? And what would be a reasonable wait and see period? 6 months, 12 months, something more, something less? Another question would be, did the loss arise from a single event, or during that wait and see period, was there another intervening event that displaced the original event as the cause of the loss? So again, you'll see that just this one defence of the insurers raises a number of interpretive and legal issues that need to be considered in order to resolve that point. Now, after we've considered all of these complex arguments around whether there actually has been a loss or not, we can then look at the basis of the claim, and if there has been a loss, on what basis is this claim being made? Now, generally speaking, the basis of the claim in the lessor's arguments have either been on all risks or a war risks claim, with lessors arguing one or the other, then with the other one in the alternate. So, for example, they would be arguing that it's an all risks claim or alternatively a war risks claim, or vice versa. So just to recap on that, so everyone is clear what the differences are between these two claims. All risks insurance covers claims for physical loss or damage, however sustained, during the period of coverage, but it's subject to an exclusion clause for certain events. And we call those exclusions, those events perils. And these essentially relate to war and hijacking type events. You'll see in this presentation and in the slides that we'll call this exclusion clause AVN 48B, which is the industry clause that's included. The war risks insurance, that covers loss or damage to the aircraft against claims that are excluded from the all risks policy. So key examples of those would be war, hijackings, acts of persons for political or terrorist purposes, or confiscation or seizure of the asset under the order by or under the order of any government. So those are the two types of basis of claim that we're looking at here. And without providing any commentary on whether a claim sits in the all risks or the war risk claim, let's have a look at those. So where a lessor is making a claim against the all risks insurers, the general argument that the lessors seem to be running is that the loss was caused by the lessees themselves in retaining possession of the aircraft, and that they're doing this for their own economic or commercial purposes. Yes, there may have been some statements coming from the Russian government or some acts coming from the Russian government regarding not giving back the aircraft, but at most, this was the Russian government facilitating the deliberate acts and the deliberate intentions of the lessees to retain those aircraft for their own purposes. And so the lessors are arguing that this retention by the lessee of the assets for their own purposes would not give rise to an AVN 48B war risk style exclusion, and so would be a claim that's payable under the all risks policy. The all risks insurers respond to that argument by saying that the loss was caused by the acts of the Russian government, and it was those acts of the Russian government that caused the lessees to retain possession because they couldn't do anything else. And therefore that triggers a couple of the AVN 48B exclusions to the all risks policy. Number one being that there were some acts of one or more persons done for political purposes. And number two being that there's been some form of confiscation or seizure of the aircraft by or under the orders of the government. So the all risks insurers are saying that there is no coverage under the all risks policy. Now, where the lessors are running a claim against the war risks insurers, the general argument of the lessors is exactly that which the all risks insurers are using as their defence. So here the lessors are saying that there was an act by one or more persons done for political purposes, or there was a confiscation or seizure of the aircraft by or under the order of the government. And so that's exactly the type of risk that is covered by the war risks policy. The war risks insurers are responding to that argument by arguing the lessor argument for the all risks coverage. So they're notably saying that the losses are not war risk coverage, but are due to the lessee retaining possession for their own commercial purposes. And they were merely facilitated in doing so by the Russian government. So the war risks insurers are saying that there's no coverage under the war risks policy as a result. So you'll see it's pretty complex, and the arguments for and against each basis of claim are diametrically opposed.
If I could cut in for a moment, there are a couple of questions, Alison. One, you might want to just highlight whether the risks covered would include political risks that you may find under a political risk insurance policy, and are all the arguments that are being made and discussions that you're making, do they apply to the operator's all risk coverage, or is it the lessor's contingent possessed insurance policy, and or both?
Yeah, so in terms of the first question, the political risk coverage, we will come on to that. but essentially, no, we're not looking at political risk coverage. We'd be looking at separate policies for that. On the second point regarding whether these arguments are being argued for the airline policies as well, I think the answer to that is yes. The airline policies, the arguments are obviously going to be run in a slightly different manner, but certainly in terms of all risks and war risks claims, you're going to have similar arguments for coverage under one or the other under those policies, as well as under the lessor contingents policies.
Yeah, one other question, which I think is useful at this stage. You've mentioned the various venues for these actions. What was the impetus for the venue in each case? Was it stipulated in the policy, or was it the choice made by the litigant bringing the action? And this may be an unfair question, but do you see different advantages or disadvantages in each of those jurisdictions?
Yeah, so the policy will partly dictate where the case is going to be tried, and although there is a certain element that we have seen of potentially looking for more favourable jurisdictions, and I think particularly in the US, we do see that some jurisdictions are more favourable than the other. So to the extent that pro-insurer or pro-lessor arguments come into play, I think that's going to be fairly relevant in the US cases. Now, one other point on the basis of the claim is that I've spoken about all risks or war risks claims. There is also in some lessor policies a standalone clause, which is called a deprivation of possession clause. And essentially, these are clauses that provide for insurance on the basis of deprivation of use and possession of the aircraft for a defined period of time. And that's pursuant to the specific clause that's set out in the policy. We've only really seen these clauses in the US market. I don't think we've seen any in the UK or the Irish market. And I don't know whether they are fairly expensive to negotiate into the policies or not, but I'm sure many people have views on that. But essentially, it's raising the question here as to whether these clauses, these standalone clauses, will provide a basis of claim which is less open to interpretation than looking at the general all risks or war risk coverage. So, for example, there doesn't seem to be any need to show any physical loss, which is one of the key points that we've been talking about, which is giving rise to a lot of discussion. And instead, what you would seem to need to show is that the lessor has been deprived of its use or possession of the aircraft for a defined period of time, so that it can't remove the aircraft from the country in which it's operating, or it's prevented from re-registering the aircraft. And those things may be easier to prove than having to show physical loss. So that's an interesting one to keep an eye on as some of these cases proceed in the courts. And I think before moving on to the next issue, it's possibly useful here to highlight that there has actually been some court direction on the element of whether there's been a loss. So very recently, in respect of a lessor claim against its insurers in Florida, we did have some judgment come out of the court there. The principal claims being made were all risks claims, alternatively war risks, and there was also a war risks standalone deprivation clause in this particular policy. The arguments of both parties were the usual arguments that we've seen across the board that we've been talking about. And then the all risks insurers filed a motion to dismiss the all risks counts, the all risks parts of the claim. And that was based on the fact that they were saying the lessor had failed to state a cause of action under Florida civil procedure law. they were saying that the lessor isn't alleging that there's any physical damage to the aircraft, which it wasn't. But the policy itself is based on there being actual physical loss or damage. And what the all risks insurers were saying is that the Florida courts have consistently held that the phrase physical damage and loss requires a distinct and demonstrable physical alteration of the property and doesn't include intangible losses, such as loss of use. So they're essentially saying that direct physical loss requires some actual alteration to the insured property. And there weren't any allegations of this actual alteration of the insured property by the lessor, because the lessor, the same aircraft was with the same lessee and in the same condition. So at the most, what the lessor was alleging was a change in the legal and geographical constructs which define the aircraft's legal use, but not any alteration in physical properties. And the insurers were saying that the allegations of deprivation of use or possession do not amount to physical loss or damage. Now, the lessor responded, obviously, in contrary to that position, and said that they had suffered actual harm and the policies cover physical loss or damage, and that physical damage is not required when physical loss, such as the deprivation of the insured property, exists. So deprivation and dispossession would be covered as a physical loss under the policy. The lessor cited quite a lot of cases in its response to the motion to dismiss, and said that under Florida law, deprivation or dispossession does constitute physical loss. The all risk insurers responded to that. They basically refuted all of what the lessor said, and they were highlighting that most of the lessor's cases that they'd cited were not Florida cases, and the ones that were Florida cases could be distinguished for various reasons, which I won't go into. The court came back with its order and it granted the motion to dismiss in favour of the all risks insurers. The court was agreeing that the language in the policy wasn't contemplating the complete physical loss of an aircraft due to a wartime conflict. And it was saying that what the lessor was essentially claiming was just that the lessee stole the aircraft when they refused to return it. The court said that the bulk of the authority was supporting the all risks insurers, although it did acknowledge that there was some authority either way. And it held that Florida law holds physical loss to require some physical change to the insured property. So some actual alteration to the insured property was necessary. It said the lessor wasn't alleging a tangible change to the property and therefore the complaint failed. Now, I would highlight that a notice of appeal has been filed for this, and I'd also note here that the war risk element of this case continues. It wasn't subject to the motion to dismiss, which was just in respect of the all risks elements of the claim. But that's obviously giving some indication as to where Court of First Instance has found in favour of all risks insurers. Now, secondly, we saw a case a few months ago that was decided in the New York courts. Now, we can distinguish this case because it was a case by the lessor against the airline operator insurers, so not against the lessor contingency policy. But it looked at what constituted a seizure for the purposes of New York law and considered whether there was an event of loss under a lease agreement. Now, the key elements that were included in considering whether there was a seizure was that possession is not required to seize an asset, and that the government taking one of the rights commonly associated with ownership, so for example, the right to exclude or the right to use, would be sufficiently meaningful interference with an individual's possessory interests in that property. It also said, the court also said that interference doesn't need to be permanent. Now, the term seizure is one of the terms that is used in the AVN 48B excluded risks under the all risk policy and is a covered peril under the war risk policy as a result. So I think particularly for New York law cases, we may have an indication here as to how the court will view whether there's been some form of physical loss and which coverage is going to respond to that physical loss. Now, assuming we have found that there's a loss and we found part of the policy that it's sitting under, the next question is whether we actually have coverage under the policy. And that's the point we're going to look at here. So we're looking at contingent versus possessed coverage. And as mentioned earlier, most lessors will have a policy that covers both. There does unfortunately seem to be a major disconnect between what the lessors think are covered by these types of cover and what the insurers say are covered. In respect of both the contingent and the possessed coverage, there's an argument about the terminology termination of the leasing versus termination of the lease agreement. Now, the insurers are arguing that the lessors terminated their leases and that one of the conditions for coverage under the policy is that there's an existing lease agreement. And so therefore the policy wouldn't apply. And that's in respect to both contingent and possessed cover. However, I think the lessors are generally very clear when they're issuing termination notices, where they're purporting to terminate the leasing of the aircraft and not the lease itself. Not least so as to maintain things like the ongoing indemnities, return obligations, and things which otherwise would potentially disappear if the whole agreement was to be terminated. So the lessors are arguing that no, there is a lease agreement in place. It's just the leasing under that lease agreement that was terminated. And the insurers are also arguing that the coverage doesn't apply where there's claims payable under other insurances, such as the airline operator insurances. And we'll look at that in a little bit more detail when we talk about mitigation efforts a little bit later in this session. For the contingent cover specifically, the lessors are claiming that the reason they have coverage under contingent policy is due to the aircraft being outside of the care, custody, and control of the insureds. Whilst the insurers are arguing that the aircraft has to suffer a physical loss whilst in the care, custody, and control of the relevant lessee. And so what the insurers are saying is that the coverage doesn't protect against a loss just from being unable to repossess the aircraft, but there needs to have actually been a physical loss whilst the aircraft is in the care of the lessee. For the possessed cover, and as I alluded to earlier on, there is an argument as to what the phrase "in the course of repossession" actually means. So from the lessor's perspective, they've served termination notices and they're trying to get the aircraft back. And to them, that means that the aircraft are in the course of repossession. And they can be in the course of repossession without termination of the leasing. So even just making demands for repossession of the aircraft would be sufficient. The insurers, however, are saying that the requirement to actually there's a requirement to actually take active physical steps for repossession when the loss or damage occurs. So the mere making of demands isn't sufficient. It's not enough. The aircraft has to actually be actively being repossessed when the loss or damage occurs. And in this case, the insurers are saying that that is not the case. So from this, we can see that even where we've established a loss, and even if we've allocated this to an all risks or a war risks claim, there's still then an argument of whether the actual policy itself is even going to respond to the event that we're looking at. Assuming, again, that we've proven a loss, that we've settled on a type of policy, and we've decided that the policy responds via the possession or the contingent policy, is there anything else that can actually prevent these payments from being made? Well, the answer to that is yes, if an exclusion to the policy can be found, or if the policy has been cancelled, or if potentially the parties have failed to mitigate their losses. So the next few slides that we're going to look at are going to look at some of these defences that are being raised by the insurers. And the first one, and a big one, is sanctions. So does the policy contain any exclusions to pay out as a result of sanctions applying? And if so, are those exclusions going to respond in this particular scenario? Most policies will contain some form of a sanctions and embargo clause, and often that will be in the industry standard form AVN 111, which, paraphrasing, what AVN 111 essentially says is that if providing insurance to an insured party is or would be unlawful due to the sanctions laws that are in place, then the insurer doesn't have to provide the coverage and won't have any liability whatsoever. So if we have this clause in the policy, is it going to apply to our situation? Well, the insurers are arguing that the aircraft are at all material times for use in Russia, which is a key element for the sanctions laws that have been put in place. Therefore, what the insurers are saying is they can't pay out under these policies, even if there was a valid claim. The EU put out some FAQs in December 2022, which were partly aimed at providing some clarity on this matter for contingent and possessed policies. And there was also corresponding UK guidance on this as well. And what the EU confirmed was that insurance and reinsurance of aircraft are not for a person in Russia or for the use in Russia, where it's provided for the benefit of the non-Russian owner of those goods, and not for the benefit of the actual user or operator of the goods who may be Russian. And this would apply when the items remain in Russia against the will of the non-Russian owner, so against the will of the lessor, and despite the demand for their return. So the lessors are running this argument as to why the sanctions exclusion won't prevent payout by the insurers. And that's going to be, I think, a key point that will be addressed during the litigation. Another defence that the war risks insurers have included is that their coverage was cancelled prior to any loss having been occurred. War risk policies, as you probably know, generally contain a 7-day notice clause, and that clause allows insurers to review or reassess the risk that they're insuring. And if needs be, it gives them the ability to amend the geographical coverage of the policy, or they can cancel the policy if there's some form of radical change that sort of changes the political conditions surrounding the policy, such as, obviously, a war between Russia and Ukraine. And so many of the war risk insurers invoked these clauses around about the time that the conflict arose, or escalated even. And they amended the policy to exclude Russia or Ukraine. And in some cases, they may have cancelled the policy. So the questions here that are being argued are, were those notices served in an effective manner? So actually, did the war risk insurers serve those notices in the way that they're supposed to? And if they did, what was the effective date of the notices of those, of the effective date of those notices versus the date of the loss? So the crux of the matter here is the timing of the notices and whether they came after the sanctions were imposed, but before the aircraft were lost, assuming, of course, that there has been a loss. A lot of that seems fairly factual in nature and easily resolved, but I think, as we've seen, even establishing whether there's a loss is difficult. So then working out when that loss actually arose, I think, is going to be even more difficult. We then have mitigation. Now, another issue that the insurers have been raising in their defences is in respect of mitigation. And if there was a loss established and all those other hurdles have been overcome, is the lessor under any duty to mitigate the losses? And if so, has it done so? Now, The standards and requirements for that are going to vary across jurisdictions, and I'm not going to go into those, but some mitigation actions may include things like attempts to repossess the aircraft, claims against the lessees themselves for payment of the agreed value, or the sequencing of claims against the operator, the airline operator policies versus the lessor policies. Has the lessor exhausted all other routes to get payment from the airline policies before claiming under the lessor policies? And a lot of this will come down to local law requirements and some of the separate actions that have been taken by the lessees in trying to get back their aircraft, which will be very factual and will very much depend upon the circumstances of each individual case. Finally, another interesting defence that's been run in some cases, not in all, but in some cases by the insurers, is that these insurance policies, the all risks and the war risks policies for the lessors, contingent and possessed policies, were never designed to respond to this type of loss. And there's other insurance policies in the market which would respond. And this comes back to the question that Dean raised. So repossession cover or political risk cover. Separately, historically, you've been able to obtain these policies, albeit they are fairly uncommon and, as I understand, fairly expensive as well. So should a policy such as political risk cover be more suitable for these types of claims than claiming under these lessor contingency policies? Also, total loss only cover, which is a payout of an amount per aircraft in the event of a total loss. Would a claim be easier under that? I think you'd still need to show loss there, but perhaps you don't need to go into quite so much detail as regards coverage and whether you've been in the course of repossession of the aircraft, for example. So I know that that's been quite a whistle-stop tour of what's essentially very complex litigation. And there really are such a large number of points that are being litigated that it's going to be very interesting to see how this plays out over the course of, well, at least the next 12 months, I would say. I would apologise if sometimes the language that I've been using during this presentation has been a little bit wishy-washy, using words like purportedly or alleged and other such terms. But as stated at the start of the session, I'm not looking to comment on whether any of the facts are true or not, or whether there's any merit to these arguments. And that's for the litigators to argue between themselves. But I am obviously happy to discuss any of these points in more detail separately with you, if any of you should wish. But what I think we can see is that this is very much an ongoing saga. I've got no doubt that there's going to be many twists and turns in the months and years to come. I think Dean and I were chatting yesterday about potentially having to give an update to this session in maybe a year's time or 6 months' time. So if I haven't bored you all to death for this session, then I am happy to come back and give an update in due course. But I do hope that you found this session instructive.
Thank you, Alison. We do have some questions, and I did hear what you just said. I'm going to hold you to it because these learning labs are great, but they're always done at points in time. And we know this is a fluid situation. And so definitely going to want to get an update from you in a few months. But there are a few questions, comments that I'd like to ask. First, kind of a basic one. There are a number of cases. You mentioned the jurisdictions. Some are talking about moving the venues to Russia and other places. Is there a glossary of the cases out there in the where one can look and see where all the cases are currently being litigated?
I don't believe that there is a glossary out there. I have a glossary, and I think the AWG has a glossary that's been circulated to its members, but I don't think that there is one that is generally available. Okay, all right. Well, and I think that's part of the interesting I guess the problem with this is that there isn't really that much discussion out in the market about what's actually going on in the cases. We know that there's a lot of these cases going on, and we know that they're unresolved. But that's why I think, I hope this session has been helpful in sort of drilling down on some of the more detail as to actually what's going on within the cases themselves.
Have you seen insurers, even within cases, kind of pleading in the alternative fact, so effectively taking contrary views to specific issues as defenses?
Yes, and I think that was very evident at the start of the process, actually, when the insurers were, for the very first case that came in, the insurers responded as a joint defence. And then I think very quickly they realised that because lessors were pleading different positions, different claims were coming in, they realised that by taking a stance, perhaps disputing an all risk claim meant that they were maybe opening themselves up to making admissions on a war risk claim. So I think that's why they've ended up very much splitting off to ensure that their defences are consistent. They're not contradicting any other defences, because of course the pool of insurers in the aviation market is actually very, very small, and these insurers will be appearing on the other side of numerous of these cases.
Can you prognosticate a bit? All these policies have limits to them, and there's, if we assume for the moment that the alleged loss is in excess of $10 billion, how would those losses get allocated to under these policies, given the policy limits that are available?
Well, I think that's potentially more of an issue in respect of the airline policies and the claims that the lessors are making against the airlines, because as you say, their policy, the airline policy, will be insuring their fleet, and how that will then be allocated if there are payouts being made that are due to be made out under those policies, how those payouts are allocated between the lessors, I don't know. At some point there will be limits reached, and those limits will be reached very quickly, I would have thought. So I think that's an interesting question, and one that the lessors will be very aware of.
There's another interesting thought, which I'd actually given some thought to previously. These aircraft have been re-registered in Russia. There's, whether there's maintenance oversight is a question. There's obviously limitations on ability of airlines to get spare parts. Are any of the lessors arguing that even if they get these aircraft back, they'll be of no value because of the amount of work that would take to get them in a certified airworthiness condition would be effectively impossible or uneconomic to the point of rendering the aircraft valueless?
Yeah, that pops up in quite a few of the lessors' claims, essentially. So there's the maintenance risk, the airworthiness risk, the cannibalization of aircraft risk. That's one of the, I guess, the factual points around the legal arguments that there's a physical loss. Okay.
I apologize. I'm trying to catch up with all the questions. I think, one of the things I've been thinking about as well is, in theory, you could have differing results, right? You've got multiple jurisdictions with multiple litigation. You could have some insurers which are found to have liability under their policies and others not. Again, you're going to have to prognosticate a bit. That seems more likely in this case, where you may have jurisdictions that, are, someone asked earlier, well, why is a jurisdiction pro insurer versus pro insured? That's just the way case law has developed in those particular cases. But how do you foresee a situation where you've got differing results? What's the implication of that?
I think potentially the implication of that will be consideration by lessors in the future of where their policies, what market they're going to look at for their policies. I mean, I don't know how it's going to come out. I don't know whether we will end up with differing results in different jurisdictions, whether we even get that far. But certainly, I think, again, at the back of lessors' minds are going to be, well, actually, is it more favourable to be getting a policy over in a different market?
Yeah. And let's just kind of in thinking outside the box a moment. So, obviously practicing lawyers, clients come to us and say, listen, I want to protect against this risk. The Russia situation is instructive, but today, based on what we know, given the situation and the uncertainty that's created, how would you suggest to a lessor or a lender in an aircraft lease to best protect themselves from this type of thing happening in the future?
I think I probably won't. I probably will choose not to answer that question, just given sort of sensitivities, I think, around the litigation as a whole.
Okay, fair point. I will say for those out there that are wondering that same thing, call your lawyer because there are things that I think you can do, but it's challenging, and the uncertainty is the problem. And, we saw insurance issues post 9/11, which caused dislocation in the market and uncertainty, and that is a problem. And eventually, the market's caught up and helped solve the problem. But talk to your brokers, talk to your lawyers, get good advice, particularly every step of the way. One of the questions related to, on a go-forward basis, how do you address lease terminations in an uncertain environment like this? I don't imagine you're going to answer that one either, Alison. But I will say they are interesting issues, and it means that everything really needs to be run by your legal and insurance advisors to be sure you're not going to cause unintended consequences. I think we're going to end it there. We're almost at the top of the hour. Alison, thank you so much. Again, we'll see you back here in a few months with an update. I want to thank all the participants. We had a good number of people joining the session live. So thank you. Stay tuned for more ISTAT Learning Labs, and we appreciate you joining. Take care.
Thank you, everyone.